Today we'll talk about the art of drafting contracts. Now, we could spend an entire semester on this topic, but for today, we'll concentrate on elements of contract drafting that might be particularly challenging for non native speakers of English. And to do this, we're going to look at a couple of contracts used by two major media companies. And so here's a preview of some of the lessons that will be taken away from their contracts. Looking at clauses and long sentences, ways to list, differences between these really important mandatory and directive terms, definitions, how to be broad and sweeping and to create exceptions when you need them, and then finally, but not at all least importantly, commas and conjunctions, all those little words that tie things together. All right, so before we start, unlike in some of the previous lectures, I want you to take your time with this one. Go ahead and just hit pause when there's a new slide with a contract term. Read through it quickly, and then once you're ready, hit play again, and you can follow along as I highlight the key things in that section. All right, with that, let's start with our first set of contract terms. This is Squarespace. As many of you know, Squarespace is a large national provider. I use Squarespace. I created my first website back in 2015, and I had never reviewed the terms of service until working on this particular lecture. So the terms of service apply to all their users, like me. What you can see immediately from this one is that they're trying very hard to be conversational and friendly and to use plain English, plain terms. Now, this might be a little bit informal if you're writing a contract for two banks, but it's a great model to follow whenever you have a contract for people who are primarily not lawyers. So in our own lease agreement assignment, it's a good type of model to follow. So what can we take away from this very first section of their contract? We've got some definitions right off the bat, very quickly done. You'll notice that for this, there's no term like here and after. You really don't need that. And then you have collectively the services. The reason for that is that you have all of these different sites, templates, products, applications, etc., all of these nouns, right? And so collectively tells your reader that these things all combined can mean the services, or really any individual ones too. So it's a useful term to have in your vocabulary. Now, I also want to point out two very small words. These are prepositions, use of and access to. With some words, you'll know already that you can use different prepositions. With these particular verbs, these prepositions are the correct ones, and it would be very hard to find correct ones otherwise. And so if you're not sure, because prepositions are hard to master, look them up on the internet. See if you can find examples of those particular verbs using those particular prepositions. Now, the other thing I want to point out is this very sweeping language, including without limitation. It's a really useful phrase for being expansive. So a synonym for this would be including but not limited to, and they mean the same thing. All right, so here is an intellectual property rights section. Again, it's being very plain spoken, so it says your user content stays yours. In a big commercial contract between two companies, you might say something more like intellectual property rights or copyright ownership, but that's how they chose to use it in this section. So I want to point out again, definitions. You got user content and your sites. So here you'll notice there's no word collectively. They could have used it, but they didn't. And I think it's fine that they did not, because it's still clear that individually these things can count as user content. Now, your sites means the sites. I like how they did that because it's very concise. Instead of saying the definition of your sites is, it just says your sites means this. Now, here we also get the first use of a word like may. May has a very subtle meaning in contract drafting in English. So what does it mean? There are two aspects of the word may. The first is that it is permitted to, as in I may go to the grocery store. I am not prohibited from doing that. It also has the aspect of it's possible that I might. So I may go to the grocery store today. Then again, I may not. It depends on if I have time. So it contains both that permission and that possibility or uncertainty component. All right, so then that is different from the word shall, as we'll see a little bit later. I also want to point out again, there's that nice expansive language, including without limitation. And here's some limiting language, except for. That's a really useful phrase too. And another phrase that you could use that's very similar is but not. So except for the limited rights, but not for the limited rights, etc. Okay, now this section gets a little bit more explicit. And as I read it, I'm getting a little bit uncomfortable thinking about how broadly I've assigned my rights to Squarespace. So look at how sweeping this language is. All these modifiers about how broad my rights are that I've given away. So if you want to break it down, you grant Squarespace, what do you grant them? All these modifiers. What it really comes down to is right and license. It's a little bit hard to see that. You have to get through all the modifiers. To what? To use, host, etc. For what? The user content. And finally, here's some limiting language for the limited purposes of allowing them to do, etc., etc. So what I want to point out here is that it can be hard to dive through all of the modifiers and content, but thinking about where you're landing is important. That's really where it comes down to it. This is also a good example of how to use parentheticals in a very effective way. So here it's just an illustration, such as those resulting from, etc. Now, just to show you how it really breaks down, these are the essential words when you take out all the modifiers. You grant Squarespace, right and license, user content. All right, so this is an example of a section where maybe if we were writing for two commercial entities, we wouldn't use the phrase important things we can do. We might call it Squarespace's reservation of rights, or maybe, power to terminate and change services. However, one thing that they're very formal about, which they have to do, is that because a lot of jurisdictions require really large, all capped or bold-faced type when you are trying to disclaim rights, they have bolded this, and that has legal significance. They also do a nice job of listing all the different things that the company may do, and they use it in this format where they have letters and numbers. Letters and numbers are great. They're a wonderful way to organize a long list in a contract in particular, and of course it makes it easy to then reference them. So here we see that the language that's mandatory is the word may. We may do this, we may do that. And here it has the same meaning that it did earlier. Both we are permitted to, and we could, but we may not necessarily do these things. All right, so there are also these two identical phrases. Now, in a brief, we talk about using variety of language, so we would not want to use the same language over and over again. In a contract, we get to do that. In fact, it's a good thing because being consistent means you're being clear and you're not leaving any room for doubt. So that's a good thing here. Now, I'm not going to go into this in depth because it's a long section about arbitration, but what I do want to point out is how it uses some limiting language and, more importantly, the demanding or mandatory language here. So you'll see that it uses a number of places shall be settled by one, who shall be selected, and then here it changes a little bit. The arbitrator must follow this agreement, and in this situation, the word must is identical to shall. It's really the same thing. However, and can award is different. That means have permission to, may, but does not need to, whereas must means absolutely must in all situations. Then again, an important restricting term here, except that the arbitrator may not. And here also, it's the same thing as shall not. There's no difference in terminology there. So let's now look at the New York Times terms of service. You can see the depressing headlines for today, unfortunately. I've been a subscriber for years, and again, I have never read the terms of service until today. So this is the section of their contract about user content. So when people write replies or comments in response to pieces. I like the way that they set up this sentence. If you blank, 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 you represent to us. And that is very useful in a lease agreement as well. You could say, if tenant elects to pay rent, dot, 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 landlord shall. And so you can use that sentence construction in a lot of different ways. And then, let's go through quickly again. You will see, oh, yeah, I won't worry about that. You'll see all these different ways in which it repeats the words, you shall not, you shall not, you shall not. However, as you can see, there's one place where it's different. You agree not to provide material and misleading information. Now, this is a good takeaway because it immediately signals to me, why is there a difference in language? Is there a meaning behind that? And I suspect that maybe the drafters of this contract chose you agree not, maybe because there's a statute behind this, a statute that said knowing consent or knowledge was important for this. But it does raise a question, and it just compounds the importance of using the same language if you mean really the same thing. Now, here are two phrases that are very useful for us. So when you say, or otherwise illegal material, what it means is that all of these things are similar in some way. Libelous, defamatory, obscene, pornographic, abusive, in the sense that they're all illegal. So this is a good catch-all, or otherwise. You could also use, or in any other way illegal, or similarly illegal. So otherwise is just a nice quick way of explaining that you are continuing the list of ideas. Now, I'm going to look at a provision in the contract that I think is less than ideal, but raises some good questions about how you use commas and disjunctions, in this case, the word or. But first, you'll see, again, lots of directive words, mandatory words, you may not, you shall not, and then a list of the things that you shall not do. Here also, shall not means really the same thing as may not. There's no difference there. So if you look at this section 2, this is about what you can't do to basically data mine or scrape the content. And you'll see that there are many, many uses of the word or. Sometimes there are commas and sometimes there aren't before the word or. So in this phrase, there are no commas before or. So I take that to mean that this phrase, software or any manual or automatic device, comma, is standalone, that it has its own meaning. But then you'll see there is a comma here before that word or. So then I think that means this is a whole new phrase, or process designed to data mine or scrape the content. Then another comma here, no comma before that, comma, no comma, comma and or, no comma, no comma. So, I'm not sure. They could have meant this to be completely independent. They could have meant this to be independent or not. So it's just good to be aware of where you're using commas, because people will make arguments about ambiguity based on comma placement. And so if there are ways to avoid that ambiguity, it's best to do that. All right, so we're going to flash back for a second to the two cases where the court really looked at non-compete language, and the drafters did, a pretty good job, but they maybe could have done better. So this first one is from Update versus Samillo. And if you remember, Samillo argued to the court that that phrase was ambiguous. He said, that should have been, is it clear that it meant only clause 1 or clause 2 or both? And the court said, yeah, it was not artfully drafted. However, it's not ambiguous. It really did modify this earlier part. And honestly, this should have gone earlier, and that would have avoided any potential ambiguity. So for us, that is helpful because sometimes just closing the gap between two parts of a sentence and putting the important parts of that sentence close together can help. And that's actually the same lesson I take away from this part of the contract from Capital One Finance Corp. So if you remember, that contract had many definitions. Competitive business was one of those. And so this is a very big, long definition with multiple parentheticals. I find it hard to understand. Part of the reason for that is because the parts of the sentence that are important are far apart from each other. So you've got engaged in by the company, okay, good, as of the separation date, good. including the business of, and that's all the parentheticals. Then way down here, you've got in New York, New Jersey, and Connecticut. So by the time I get there, I'm not sure what was happening. So one easy way, oh, and then here's language again. Broad language, including but not limited to, which is helpful. So what I would suggest in this case then is moving everything up so that you have in New York, New Jersey, and Connecticut right where it probably should be. And then the rest of it is about what is included. Okay, so I know this was a very dense set of slides, and so what I've done is created a PDF version of just the visual parts of it for your reference. I hope that's helpful.